Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. So today I would like to present about the definition of rape, the punishment of rape, the example cases of rape in Malaysian law authorities and Islamic law authorities. So, the definition of rape under Malaysian law. According to the Malaysian Penal Code, rape is defined as sexual intercourse with a woman against her will or without her consent. The second one is sexual intercourse with a woman is also rape when the first one is her consent is obtained by putting her in fear of death or hurt. The second one is when she unable to understand the nature and consequences of what she is consenting to. The third one is when her consent is obtained by using a position of authority, a professional relationship or other relationship of trust. And the last one is sexual intercourse with a girl under 16 years of age with or without her consent is also rape. Okay, the punishment for rape. According to the Penal Code section 376, those who committed rape will be punished with imprisonment for a term up to 20 years with whipping. Besides that, punishment with imprisonment for a term up between 10 to 30 years along with whipping can be imposed on those who committed rape under these circumstances. The circumstances are, in addition to the offence, causes hurt to the woman or another person. The second one is, in addition to the offence, puts the woman in fear of death or hurt to herself or any other person. The third one is, commit rape in the presence of another person. The next one is, rape a girl under 16 years of age without her consent. The next one is rape a girl under 12 years of age with or without her consent, and it is considered as statutory rape. The next one is commit rape with a woman's consent with the use of authority over her due to a relationship of trust or a professional relationship. And the last one is raping a pregnant woman. Okay. The example cases for rape in Malaysia is we can see the public prosecutor versus Muhammad Musa bin Ahmad cases. It is rape cases in Malaysia. So the court held in this case is the respondent's sentence was substituted with a sentence of 12 years imprisonment with no whipping. Okay, the summary is respondent was convicted on his own plea of guilty to a charge of rape under section 376 of the Penal Code and was sentenced to 24 months imprisonment and 1 stroke of cane by the Learned Sessions Court Judge SCJ. The public prosecutor appealed against the inadequacy of the sentence. The respondent had raped a 14-year-old girl who later gave birth to a baby. The respondent was the younger brother to the brother-in-law of the victim's mother. According to the victim, she went to the respondent's house during school holidays when the respondent had lured her and raped her. So this is one of the cases that define rape cases in Malaysia. Okay, so in Islamic law, what is the punishment for rape? The punishment for a convicted rapist. The penalty for a convicted rapist has been considered to be the same as for the had of zina, the had of hirabah, or to come under the category of ta'zir. So rape is one of the ta'zir offences in Islam.
In conclusion, Quran and Sunnah contain many statements which forbid some types of human activity and classify them as sins. Allah as the lawgiver has determined the offence, so the Qadi has only to determine the suitable punishment for the offence. In Islam, human sexuality is governed by Islamic law. Muslims call the Islamic law as Sharia, and rape is considered as a very serious sexual crime in Islam. Accordingly, sexual violation is regarded as of moral of divine law. And the opinion on how to overcome, the government must enforce the hudud as the law of the country. Moreover, the people need to raise awareness about rape to all women and girls. In addition, the government also need to elevate the dignity of women. Referring to the case Public Prosecutor versus Muhammad Musa bin Ahmad, a guilty plea ought to be considered in favor of the accused only when all other factors and circumstances surrounding of the commission of the offence justify such a consideration. There is no automatic rule that a guilty plea on its own entitles an accused to be lesser punishment. As in the case mentioned, the respondent was convicted on his own plea of guilty to a charge of rape under Section 376 of the Penal Code and was sentenced to 24 months imprisonment and 1 stroke of cane by the learned Sessions Court judge. By allowing a respondent a discount for pleading guilty, the learned Sessions Court judge underscored the advantage of lightening the court's workload, thus relieving delays and backlogs, saving the cost and inconvenience of trial and saving the victim and witnesses from the trauma involved in giving evidence at the trial.
Drug offence is under Islamic criminal law are penalised under the term hudud, meaning fixed penalty. In Islamic law may help the judges in exercising their discretionary powers in drugs-related cases and thereby fulfill the higher objective of the Sharia in the practice of the Malaysian judiciary. The Dangerous Drug Act 1952 has been amended twice. In 1975, Section 39B was inserted, introducing the death penalty, life imprisonment, and flogging as punishment. A further amendment in 1983 made the death penalty mandatory for drug trafficking. According to Islamic criminal law, it is the intentional involvement in narcotic offences, such as the selling or possession of narcotic drugs, which causes the application of criminal provision and not an intentional element.
The case of D.A. Duncan versus Public Prosecutor. The 4 boats were carried in a bus which entered Malaysia at Changlun. The bus had come from Hat Yai and carried the appellant as a passenger and visitor. It had to stop at the immigration and customs checkpoint at Changlun, the border town. Unfortunately for the appellant and unknown to him, an order had been issued for his detention. At the immigration office, he was told he wouldn't be allowed to proceed in the bus and he had therefore to unload his luggage. He held his briefcase and he had to return to the bus to recover his other luggage. He was the only one detained and therefore the only one with reason to unload. What was unloaded was 1 other bag and the 4 boxes. The appellant did not dispute that the bag was his, but strenuously throughout his trial denied any connection with the 4 boxes. The prosecution evidence traced the loading of the 4 boxes in Hat Yai to their detention at Changlun. Evidence was adduced that the appellant had to pay excess fare for the bulky box and that he was the one who had brought the box along for transport. Part of the evidence consists of a deposition at the preliminary inquiry of a witness who could now not be traced. The deposition was admitted over the protest of counsel for the appellant. We are, however, fully satisfied that sufficient evidence was adduced to justify the court's admission of the deposition under Section 32 of Evidence Act. Evidence was also adduced that at Changlun the appellant was the active party in the unloading and it was he who, at the request of the customs, opened the box. The box were found to contain Mount Siamese face masks, but the dangerous drugs, which were subsequently found to be hidden inside the mask, were not discovered until later in Kuala Lumpur, again in the presence of the appellant. In the meantime, the box remained in the custody of Chief Inspector Yo. A mixed bag of dangerous drugs to wit 1,647 grams of cannabis, 683.86 grams of morphine, and 933.21 grams of heroin was found in 4 boxes. The dangerous drugs were in sufficient quantities as to lead to the interference as a matter of common sense of trafficking in dangerous drugs against anyone found to have in his custody or under his control, the box containing the said drugs, as would lead to the interference of possession thereof under Section 37D and bring the offence under the more serious category under Section 39B(1)(a), for which the penalty is death or sentence for life. The punishment for a convicted drug dealer has been considered the same as drinking alcohol because it is intoxicating and brings harm and falls under the category of ta'zir. The appellant is likely to escape with life imprisonment and having regard to the quantity and variety of the drugs, with only 6 strokes. The appeal against conviction is dismissed.
To conclude, why drugs can become a ta'zir offence? As we knew, terminology ta'zir is characterized as an infliction of discretionary punishment for transgressions against Allah or an individual for which no predetermined punishment, which is penance, tawbah, or expiation exists, kafarah. In the past, Arab people have alcohols which used for their ceremony, but in this new century, most people use drugs for medication and their desire. A number of juries suggest that drug-related offences are analogous to intoxication. Furthermore, prohibiting illicit drugs needs to be in tandem with restricting its production, trading, and trafficking. The decreed punishment should not inflict physical harm on the offender. By referring to the third guideline of ta'zir, it is proposed that judges circumvent any form of punishment that could result in bodily injury. Arguably, imprisonment and measures to reform the convicted offender may be the best option for judges when sentencing drug traffickers. Same as D.A. Dunchan v. Public Prosecutor, the court held that the appellant charged with a life imprisonment and not death sentences. Therefore, the Quran mentions intoxicants, khamar, and more specifically alcohol. It is cautious about drug usage. Allah subhanahu wa ta'ala says in the Quran, there is tremendous sin in both and some benefit for people. The evil is more than the benefit. Surah Al-Baqarah verse 219. The previous verses have been made ineffective as far as social drinking is concerned. Through a process known as the rules of abrogation, an-nasikh wal mansukh, in Surah Al-Ma'idah verse 90, Allah subhanahu wa ta'ala said about the ban on alcohol, O believers, intoxicants, games of chance, idolatries, sacrifices at altars, and divining are all abominations, the handiwork of Satan. So turn wholly away from it that you may attain to true success. Clearly, who commits drugs has made a transgression against Allah. Even though in the Quran it did not mention about drugs, we use the abrogation rules, which is the old rules, and apply the punishment on new cases. Same as alcohol, drugs give the same effects like dizziness, addiction, and more disease to human beings. If it consumed uncontrollably, we can refer to the cases that happens in Malaysia. Short story, most of them steal money to buy drugs, kill, and threaten innocent people just to fulfill their wishes over drugs. According to the most scholars, drugs has the same intoxicating effects as alcohol. They used a number of criteria to establish that if it is forbidden, such as harm to health, harm to the health of others, waste of health, the presence of sedative effects, the taking of one beyond one's senses, the distortion of rational thinking, intoxication, and clouding of the mind. Also, distortion of physical and motor skill. It is clearly shown that everything that I have mentioned before happened. So, how can we overcome this issue? In my opinion, we can overcome this kind of offense in Malaysia by set up rules seriously and more strictly in drug production, ensuring that only the needy use drugs for medical purposes, not for self-satisfaction that lead to harm. Secondly, conduct more in-depth investigations into illegal drug trafficking in the community and provide appropriate punishment. With the heavy punishment like that, the distributor will not dare to do the same act for the second time. Thirdly, conduct a campaign on the harms of drugs, especially to the rural and less educated community, so that they have a better understand and know the evils of drugs if they consume them incorrectly without any consultant. Also, warn them as well as show the punishment that has been carried out to the offenders so that they become more vigilant about the seriousness in drugs. That's all from me. Thank you.